Hey, y'all. Welcome back. I am the loud little ducky. I'm hoping that my audio is not screwed up today. I know a lot of people were having issues with audio yesterday in StreamYard, and I wasn't the only one. So hopefully it is all good over here. Um, so the last 2 days we went over the bar's charges on Gingras, and we went over Gingras's responses and the things that he admitted to. Now, he has been doing a bunch of rage blogging as well in the midst of all of this. And it just shows how far he has derailed, and he misses the point. He's gone off the tracks. It just makes no sense. And his version of events is not based in reality. And in my opinion, it's a flat out lie, or at least disingenuous to sit here and claim the things that he is claiming. It's unethical, unprofessional, and the things that he's being charged with on things, he is still doing some of those things. In regards to saying things about the judge, he continues to say stuff about the judge. He can't stop. He won't stop. And he wants to talk about, oh, it's my First Amendment right. Not when you're a lawyer. Maybe after your bar card is removed and you're just a civilian once again, maybe. But this is not the way. And the fact that this is how you conduct yourself is despicable. So, the first blog we are going to go into is, because I don't believe I went over this one. Okay. So let's go over this one. All right. So this one was called Some Very Ominous News, Maybe. Thunder Lightning Strike. And this was on March 9th, 2026. At 3:06 p.m. is his update to this. But he says, my process server just made contact with Mata's JA. She said Mata was not on vacation. She is just refusing to accept service. My guy, his name is Gary, responded, this is not legal. She can't refuse service. Apparently, with that, the JA ended the discussion. So Gary is going to, on his own, file a complaint against Mata for violating Supreme Court Rule 54D1. I didn't even suggest this. He brought it up on his own. Well, if he's your guy, I question I just question him at period to be associated with you. I didn't even suggest this. He brought it up on his own. Members of the bar have a duty to cooperate with the bar like I am doing. Oh, I'm sorry it's so late, Calamity. But welcome, or come back and watch on replay. I'd rather you be rested. Violating the duty is grounds for discipline. That's true for Mata and anyone else, although Gary is still trying to service Mata's dad. The next step, I called Jim Lee to discuss this. He was busy, but he said he would call back later this afternoon, absent some other agreement. I'm going to file something reporting all this to the PDJ, and I will ask her to allow alternative service on Mata per Supreme Court Rule 47C1. And everything that I believe that he has filed has been denied. And he says after that request is granted, which it will be, it actually wasn't, if that's the ruling I'm thinking about. If Mata still refuses to appear, I will ask an order for show cause, requiring Mata to appear and explain why she should not be held in contempt. Yeah, they basically said they weren't doing any of this shit. I know it sounds dramatic, but keep in mind, the same thing just happened with, of course, he brings politics into it. Since the penalty for contempt can include jail, I assume Mata will cave too. Always bringing politics in it. At the end of the day, if Mata continues to hide, the result is simple. Jim Lee won't be able to call her as a witness. No witness means I will win that part of the case. Okay, one part of the case. Good thing there are multiple parts of this case. Since the Mata claims are squarely within the anti-SLAPP law, it also means I can seek fees and compensation from the bar when they lose that motion. I knew this case was crazy, but I never expected this. But at the same time, I will turn blue in the face repeatedly. People with nothing to hide nothing. Yeah, well, maybe apply that to your client, because she has stuff to hide and she hides so much shit. So it's amazing that you apply this logic to everybody else other than your client. Then he wants to talk about some other bullshit that doesn't matter. He says, the issue, my process server got in touch and said it appears Judge Mata is evading service of my subpoena. Yikes. And this is where he did the update, because he wrote this part first, thinking that maybe she was on vacation or taking a leave of absence for personal reasons. He questions maternity. I don't know why he even needs to put that in. Maybe she just quit. Like, absolutely non-logical thinking. His process server left messages that have not been returned. He said was not in court all last week. He tried emailing the department to see if they would accept the service, and no one responded to him. She said, obviously, there could be an innocent explanation. There could be, but you never go with the innocent explanation because you think everybody is just evil and thinks like you do. Sometimes judges go to judicial conferences, but surely someone from her department would still answer the phone. They can't all be gone. They don't have to accept service on her behalf. Here's why this is such a bad sign. Lawyers have an ethical duty to comply with requests from the bar. If you are asked to provide information to the bar and you refuse, that's grounds for discipline by itself. Well, if she is breaking rules, then okay. But right now it doesn't seem anything. It doesn't seem like that, and you have no proof of anything else. Usually you have no proof when it comes to your accusations. They can't evade service. It says that means one of two things. Judge Mata is unreachable, including by phone and email, for a totally legitimate reason, such as vacation or attending a conference, or something is seriously wrong. Given what happened last week, I am afraid it's the latter. To be totally candid, I obviously have my opinion, and this is only my opinion, not a fact. I think there is a very, very serious cover-up going on here. I can think of no valid or legitimate reason for the CJC to withhold information if that information is good for Judge Mata and Jim Lee. Just like in the criminal case, it could be the fact that, like, Laura cannot have access to certain information because Laura cannot be trusted in what she would do with that information if she had it, but the attorneys can have it. And so they might not trust you with certain things. Do I think that he should know what Judge Mata is going to testify to? Yes. but he has her bar complaint. So he knows what she is testifying to and what her complaint was about him. So he's not clueless. It's not like he hasn't seen anything and he's just like, "Well, who is this judge on this witness list? How do I know what she's going to say about me?" Yeah, he just continues. But he had to make sure that he put on there, "This is only my opinion." But the thing is you are doing it on your law office website, and as a lawyer, and in your capacity as a lawyer during a disciplinary hearing. So this is still all in your capacity as a member of the bar. And the bar does not have to allow you to behave like this and keep your license. They don't have to. Oh, no, I don't want that. Mm. Well, that's not great. Mm, 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 mm. Okay, we're just going to go with this. All right. So he thinks it's the latter. Um, but wait, there's more. Sir, we are not at a 2 a.m. commercial. Over the weekend, I spent some time looking at Jim Lee's disclosure statement, particularly regarding what he said about Judge Mata. Just like in civil cases, the bar rules require Jim to provide the names, addresses, and telephone numbers of any of the witnesses whom the disclosing party expects to call at the hearing, with a description of each witness and expected testimony. You know that you have a description of the witness, you know her expected testimony, you know her name, and they can give you her business address and phone number. They don't have to give you the personal shit. In my opinion, I don't know. I'm not a lawyer. Maybe they do, but I think she can just list that so that he doesn't have access to anything that's not necessarily public. Do I think will figure it out and can figure it out? Yeah. Jim's disclosures do not comply with that rule. He listed Mata as a witness, but gave me zero description of her expected testimony. That's improper. Her bar complaint was her description of the expected testimony. So I don't know how improper it actually is. Once I realized this, I sent an extremely long email message to Jim Lee. That is something I don't think you're lying about, is sending an extremely long anything. Because we know that you and your client like to go on these extremely long narratives about shit. Explaining my position and asked to meet and confer with me today by 5 p.m. Again, I'm not trying to be unfair with short deadlines, but this process is moving at a light speed, so I really have no choice. Well, now it's moving at light speed, but before it was taking too long. So long that you can't remember things anymore. If he doesn't respond, the next step will be filed notice with the judge advising her that Jim has not complied with the disclosure rules. I intend to file this today unless Jim addresses my concerns before. Note, this happened last time I dealt with Jim in 2022, which that was interesting to figure out, is that it looks like the case that was set to go forward in September of 2022 against Gingras, Jim was bringing that case too. So Jim has dealt with Gingras before, and Jim might not like Gingras. And so should maybe a different person have handled it? I don't know. But if somebody else needed to handle it, I would expect them to move him off of it, or you broke the rules. But the thing that happened in 2022 that is, and they had to dismiss it, is because the person that was going to testify for those disciplinary charges backed out of testifying. And so they didn't have the proof or the evidence or a witness anymore to state this is the stuff that happened. And so they had to drop the case and dismiss the case against Gingras because a witness backed out. I don't know why the witness backed out. I would be very interested to hear about that, because is it because she was afraid of Gingras and his unhinged behavior and she didn't want to put herself at risk because he threatens people? Or she didn't want to be involved in it? Maybe she wasn't sure. Maybe the case wasn't as strong. And it seemed like then maybe that witness was the only witness to the charges they were bringing him. Where in this one, Judge Mata is not the only witness to this and his behavior. So even if one charge gets dismissed because a witness doesn't cooperate and they can't bring those charges all the way through, doesn't mean that his whole entire case goes away, because there are so many charges against him that involve so many different aspects and people. But okay, like Jim clearly doesn't like him. And Jim is the one that has brought the charges on him, at least in 2022 and now. So I see why Gingras does not like Jim, because he seems to be the bar guy that is always going after him. I don't know what their diagnosis should be or is. They're both completely off their rocker. Just don't know in the technicality of what. Hello, Teresa. Hello, corn-fed. Gigolo. Huggalo. We'll just call you corn-fed, okay? All right. So he talks about saying that Jim Lee is not following through with the disclosure rules that he's supposed to, and he's saying that it's the same thing in that case, but he says it's too early to say. But he says, when you have a winning hand, you show your cards. When you don't, it looks like this. No, not necessarily. It would only be similar if Judge Mata completely backed out of testifying. And Jim did move to drop that case due to that witness not testifying and wanting to testify anymore. And so he says, after Jim moved to drop the 2022 case, I was a nice person. I do not believe you. Juggalo would be the phonetic. Corn-fed juggalo. Okay. I can do that. Hello, Jupiter Jane. He said, Gingras says he was the nicest person and filed a notice telling the judge I had no objection to Jim's request. But here's the thing. Gingras says he was nice and was okay with just dropping and dismissing the case. No problem. Let's just leave it at that and we'll move on with our life. But Gingras, of course, now is saying it is different this time. Jim has spent nearly 2 years harassing me and retaliating against me. So he just let everything go from 2022 to 2024. And then all of a sudden he picks up this harassment of you. Maybe because he found out the shit you were doing and you were still doing shit once again. And Jim believes that attorneys like you do not need to have their bar card. Jim doesn't like attorneys like you. He thinks you're a snake. But he says that Jim is harassing him and retaliating against him for engaging in what he calls lawful and protected speech. That is not the only thing Jim is going after you for. So, not true. Is there part that you say is lawful and protected speech that might not actually be? Yes. He filed a complaint that contains multiple false statements. I disagreed with that when we went over when he said there were misstatements of things. Um, how I do not agree with certain things on that. If he tries to drop this case like he did the last time, I will not agree to just let him walk away. So you're doing what Clayton did. Where Clayton would not let Laura just dismiss and walk away. He was making sure that Laura was held accountable. And so he's saying that if Jim tries to drop this case, he is not going to let Jim just get away with it. He's going to make sure Jim is held accountable. But he hates that Clayton didn't just drop it and let Laura move on with her life. That Clayton was holding her accountable. But here he's doing exactly what Clayton did, except for he's doing it to the bar guy. Oh, horrorcore. Okay. I don't listen to much of those things. I like songs from each of those artists, but it's not my main jam. And so then he talks about the anti-loss that in 2022, he says the anti-SLAPP law didn't apply to the case because that change came days after his dismissal in 2022. Because the change for the anti-SLAPP law came in September, as well as his dismissal back in 2022. But now, in this 2026 case, the anti-SLAPP law does apply to his case. And he says the newer version that he says he's entitled to fees and damages and for Jim's illegal attack on his constitutional rights. So he says he will not agree to a resolution of this case unless it includes a large check from the Arizona bar to him. Which, good luck, I guess. I don't know what to tell you. And so he does have these there, which also, I know you've heard him talk about Andrew Ivanchenko. And you've heard him talk in his blogs about this guy. This guy apparently comes from this 2022 case. So we at least know where that guy kind of originated from. And I will put those two documents that he brings up in this, I will put those in the description box if y'all would like to read those. All right, let's remove that. Then the same day, he talks about Jim dropping the hammer. And Jim saying to the judge, "I win." So this is his opinion on Jim's motion for judgment on the pleadings. And he says, "I would normally share this document, but not yet. I may want to put out a video explainer first." Ugh, nobody wants to listen to you. Jim's motion contains almost no substance, so sharing it would not be super helpful. I will go over that in a pre-recorded video and put that out. He said, "It's seeing it won't tell you anything new. So what is a motion for judgment on the pleadings? It's a way of ending the case early. And that Jim is asking to end the case immediately. No trial, no evidence, no MATA, no defense. Jim just wins. He says for the next steps, he is asking the judge to schedule a hearing to determine the correct punishment. Bear in mind, that doesn't mean the motion has been granted or that he has any chance of winning. I just talked to a friend about this who asked me on a scale of 1 to 10, how effed are you? And Gingras obviously says 0 because Gingras only works in 0%, 0% percentage and 100%. I don't know why I couldn't say percent. 0% and 100%. On 0 to 10. Like he cannot be in the middle. He always has to be at one extreme or the other. But he says, if you're not a lawyer, let me explain something about how stuff works. Let's say you're in a car accident. You file a lawsuit against the other driver. You claim the other driver ran a red light and crashed into your car. You claim this injured you. Let's assume the other driver responded to your complaint as follows and says, yes, I admit I was driving. I admit I ran a red light. I admit I caused the crash and injured the plaintiff. I admitted everything. They literally didn't dispute a single thing. What happens next? Well, again, if you're not a lawyer, you may not know this, but the main function of the court is to resolve factual disputes. Yes, judges are also there to interpret the law, but that's a secondary function. When the parties do not agree on the facts of what happened, meaning the facts are disputed, the main function of the trial is to have a jury or a judge in the bench trial resolve those disputes. The jury listens to each party's story and then decides which story they believe. So when the facts are in dispute, it becomes a jury's job to decide. The fact finders, they resolve. Okay. But what if there are no factual disputes? What if the plaintiff says the defendant caused the crash and the defendant admits he caused the crash? What then? He said in a case where everyone agrees on what happened. He says there's no need for a trial. Instead, the judge can resolve the case as a matter of law. That can be done through a motion for summary judgment, but it can also be done through what's called a motion for judgment on the pleadings. So it's basically telling the court, hey, judge, both sides agree to the facts, so we don't need a trial. You can simply just rule on the proceedings. Most of the time, a defendant will use this type of motion to have a junk case thrown out. I've done that many times. Well, just because of the way you do things and why you do things is not usually why everybody else does things. He says it is fairly rare for a plaintiff to use this type of motion because most of the time the defendant does not admit everything. But yes, folks, that's literally the position Jim Lee took. He filed a motion telling the judge there was no facts in dispute. He said, I admitted everything and therefore he wins. He said, folks, if this was a normal civil case, Jim Lee would be sanctioned. No, he probably wouldn't, but okay. Jim is 100% wrong. Like I said, he deals with 0 and 100. Literally every part of his argument is wrong. Here's why. Jim's argument basically goes like this. The bar complaint says Gingras said X. In the answer, Gingras admitted I said X. Therefore, the bar wins. This is literally his entire argument. Is he right? Yes or no? Is he right that I did not deny certain things? That's true. Yeah, but the thing is, by you admitting to doing the things that you did, and if the judge says that the things that you did are in violation, then Jim does win. The bar would have to find that the things that you did in all of the scenarios you're charged in didn't violate. Could the judge find that you violated some things and in some of the charges and not other charges? Yes. And as I was explaining yesterday, he admits that pleadings said what they said. He admits that they were filed. He admits that those things that were in the filings were in the filings. The part he denies is that he only denies the fact that those things violated any rules. So he agrees to all the facts. He just denies the fact that they violate rules. He thinks that he violated no rules in anything that he did. And I don't know that a judge is going to see that he violated no rules at all. Yeah. So this blog is basically about that. And oh dang, what happened here? Ah, okay. Yeah, he admits to things, but he says, but does this mean Jim Lee is going to win this motion? Absolutely not. Here's why. The law is 100% clear. True statements cannot be punished. Yeah, but you don't have true statements. You have wild speculation, not with facts. And your behavior on witness intimidation could be your biggest problem, which has nothing to do with your First Amendment. Own legal authority says the U.S. Supreme Court says this. So sure, I admitted I said the stuff quoted in the complaint, but I had never admitted that anything I said was false. No, you don't have to admit that it's false. Without that admission, there are factual disputes here, tons of them. Thus, there is no chance at all Jim can win at this stage. Sure, he might win later if he provides receipts, but that's a question for another day. I think that a judge could rule that your behavior is unethical, and therefore he could find that you lose. I think a judge could find that. I don't know if a judge is going to, and he's going to wait or she's going to wait, but the judge can be like, you admitted to doing all these behaviors, and all of these things violate the ethical rules. So therefore, no, you're being punished, Gingras. So I don't agree with his assessment here. Again, I'm not a lawyer, but that is just me. He says on a motion for judgment and pleadings, all allegations of opposing parties' pleadings must be accepted as true. Here, I am the opposing party. My pleading, my answer explained that I did not lie about anything, and that all my statements are protected speech. I also asserted a defense, which was that Jim Lee's interpretation of the rules was unconstitutional under binding U.S. Supreme Court precedent. And under the Arizona law, the PDJ must take my side as correct, which means judgment on the pleadings cannot be granted. So I don't know if they'll be granted. He's just doing it because you admitted to a bunch of shit. Which, yay, you admitted that stuff, but it still doesn't make what you did okay and ethical. Judgment on the pleadings should not be granted if upon examination of the entire record it is determined that there are disputed facts which, if true, could affect final judgment. Again, you can only seek judgment on the pleadings when all material facts are undisputed. Here, there are tons of material facts in dispute. Did Mata look at social media? Did she talk to her dad about the case? I could go on and on. Judgment on the pleadings can never be granted with the underlying facts are disputed. But you made these statements on a bunch of speculation where there is no proof to have you believe that you could have reasonably that this is what happened. You have no evidence that points to your version of events. You just came up with the most outlandish stuff. And when you said those things, you knew that you don't have anything to back up what you said. And the thing is you're not only being charged with shit with Mata. That's not the only thing you're being charged with. This reminds me of Proctor being like, oh, it's about what's on my phone. No, it's not just about what's on your phone, Proctor. There are other things that got you to where you can't be a police officer anymore. But Proctor always was like, it was the cell phones. It's the cell phones. No, there were other charges, Proctor. You're just focusing on one of the charges. And that wasn't everything. And Gingras is doing this here. It's just about my free speech. It's just about no, it's not. There are plenty of things that have nothing to do with free speech. And it goes to, is your conduct ethical or not? That is the question here. So then he cites some stuff. My take is pretty simple. Jim Lee either has no idea how this type of motion works or he just doesn't care. I've had this for some time. The point of slap action is never to win. The point is to harass, to punish, to exhaust. Anyway, no worries. I will file my response to this in the morning. We'll probably share both when I'm done. He says, based on a conversation he had with Jim, it appears the only reason he filed this absolutely improper motion. That is not what Jim said. Jim didn't say, I filed this improper motion today because he thinks it will block my efforts to get info from and about Mata. He told me he does not see any reason why I need the CJC records. Because per Jim, the case is over. Except it's not over, Jim. You have a burden of proving my speech was false. The CJC info will prove what I said was true. I think until that is resolved, the case is not over. Some of it is not about whether it's true or not. Some of it's about, are you allowed to do this stuff as a role as a lawyer? I looked up how many lawyers have sured the AZ bar. DG blog post comes up as 4th. Oh, sued. His SEO game is stronger than LO's. Yeah, he's charged as by the bar. He's not being criminally charged for this. If he was being criminally charged for this, that would be another thing. But that's not what's happening. Yeah, and it's amazing that the bar is even doing anything because the bar a lot of times doesn't do anything. And the fact that they have so much on him and they also dismissed a lot of things that they would have on him says a lot. But I just think the fact that he's in his capacity as a lawyer is what's going to hurt him. because it's not about whether he's going to jail or not. If he was going to go to jail over this stuff, then I would be backing Gingras if he was facing jail for it, because I don't think he deserves jail for it, for his speech. All right. Let me see. Here we have, he wants to talk about bar stuff is like Han Solo taking the Millennium Falcon into hyperspace. I have to take a break for lunch, but a few quick things. All right, so let's look this up. Hey, Texas packet. Mata's father was served. So this was as of March 10th. So March 10th, next day, Mata's father was served with a subpoena. He says, I tried to avoid this. I previously texted him and got no response. I mailed him a friendly letter, no response. So now we're doing it the hard way. I spent the money to have him personally served. He now has a matter of days to hand over documents. If he does not comply, I will ask the PDJ, which PDJ, if you do not know, stands for Presiding Disciplinary Judge. For an OSC, contempt under Supreme Court Rule 47H4, a civil contempt order can include holding a witness in jail until they comply. CJC does not share his beliefs. I've literally had it happen in a case. Not kidding. Of course, he has. And let's see, when was... Oh, this is his guy, Gary, doing this. And it shows that he served. My process server, Gary, made 4 attempts to serve Mata. He has given me an affidavit outlining those attempts, which included a flat-out refusal by Mata to appear and be served. According to Gary, who has been doing this a long time, it is extremely disturbing that a judge who admonishes people in their court for evading service is herself evading service. It is not only unethical, but raises serious legal questions. And then it talks about, he says, I agree with Gary. Yeah, he's your guy. Of course you do. Or maybe Gary just agrees with you because he wants to work for you. I don't know. Evading service or refusal to cooperate. Evading service or refusal to cooperate with officials and staff of the state bar, the committee, the presiding disciplinary judge, a hearing panel, or conservator appointed under the rules acting in the course of a person's duty constitutes grounds for discipline. CJC does not agree. And he said he told Jim Lee about this, but Jim Lee could care less. And he says he's glad to know that he's in charge of protecting the public by ensuring all lawyers follow the rules. He says the rules are pretty clear. A witness that evades service, I can ask the PDJ for help. This will be done today. I'll also make a video about the motion Jim filed yesterday. I will post that shortly. Oh, goody. So the attempted service, they tried to serve her on the 4th. He says, I hit the intercom for the judge and no one answered. Another judge's assistant came out and asked if anyone was in Mata's division. She told me no one was there today. Then on the 5th, at a different time, so he served different times and different days. He again hit the intercom for the judge. He said he saw on the calendar on her room 102 that she had a hearing at 4:15 listed. I was told again that no one was in the office, which he was there at 4:30, and the hearing that was on her calendar in room 102 was listed at 4:15. So she should have still been there, is what he's saying. Maybe it was a 5-minute hearing and he just missed her. Who knows? On the 6th, he left a message for the judge identifying himself as an officer of the court and that he had a subpoena Deuces Tecum to serve the judge. I did not get a reply the entire day from either a judicial assistant or Judge Mata. On the 9th, at approximately 2:25, the judge's assistant for Mata finally called me and told me the judge would not accept service and to serve the AG's office. I told her it must be personally served, as she should know, and that I would file a complaint with the state bar if the judge refuses to accept service, and the judge's assistant hung up on me. It is extremely disturbing that a judge who admonishes people in their court for evading service is not only unethical, but raises serious legal questions. I highly recommend the use of alternative service since the judge has adamantly refused to accept service and has evaded service. This is considered to be personal service. The fee I charged for the service was $60. Okay, Gary. Good for you, I guess. It sounds like he likes DG and he agrees with DG. All right. Let's see here. Let's see. He's got here. He filed the motion for alternative service. He says that wasting time, avoiding service is a waste of time, plus it makes you look guilty. Well, isn't that interesting? Because guess who evaded service for Greg? Your client, Laura Owens. Yep. Guess that makes her look guilty in your eyes, right? But only for Mata, not Laura. Laura looks innocent if she's doing it. Judge Mata looks guilty. If you have a strong defense, don't even think about dodging service. Only the guilty do that. Let me accept service by email and we'll get straight to winning in court. That's a power move. Don't hide. Confront with your best truth. Hiding is weak. It's unprofessional. And it's ultimately futile. It never works. It worked for your client. My prediction, if the court grants either my motion to compel the CJC records, or if we reach a point where either Mata or her dad are served, refuse to comply, and then are hit with OSC contempt, that will be the end game. And at this point is coming soon. Lots of steps along the way, but the clock is ticking and we're clearing hurdles quickly, except for you're not. If either of these things happen, MTC will be granted or OSC contempt being issued. The game is over. Jim Lee will either ask me to consent to a dismissal or he will just move to dismiss like he did last time. That's my prediction. Well, I guess we'll see if your prediction comes true. And then he talks about he follows the strategy used by his friend Mark Randazza. Yeah, Greg tried to get an order on her and couldn't because she evaded service. Clayton got a harassment order, but Greg did not. All right. And now he's responding to Jim Lee's hammer. Which he was I don't know why he keeps talking about Jim Lee's hammer. A bit obsessive to me. It's been a long day, so I won't do my normal 1,000-word thing. Fun fact, I totally forgot I did a motion for judgment on the pleadings in LO versus CE. Yeah, and you lost that motion. He says, I lost that motion, unfortunately, just like Jim Lee will lose this one. The video explains why. If you want to go watch the video, go ahead. I am not. And if Jim Lee loses on the pleadings, okay, then it just continues to go to trial or whatever. It just continues. Let's see. All right. Normally, I wouldn't want to share something like this without also adding my response, but here's Jim Lee's motion for partial judgment on the pleadings. Let me explain what Jim is trying to do with this. You'll remember Jim Lee filed a long complaint with tons of allegations, right? I don't even remember the total number of claims/charges, maybe 6. Well, this motion asks the court to end the case in Jim's favor, but not with respect to every claim. That's why he's calling it a motion for partial judgment. Here's why it's partial. Rather than saying I win on everything, Jim picked the best 2 claims, and he is only asking the judge to rule on those 2 things. His claim, I violated a court order by filing documents unsealed, even though the order said nothing about sealing, and it wasn't even an order. And his claim, I made false statements about MATA. Got that? The JFCs are assholes thing is not a part of threatening Maricini, is not a part of it. All the other made up nonsense is not a part of it. Okay, did anybody say it was? Just the court order and MATA comments, only those 2 things. Is Jim going to win? You should withhold judgment on that until you see my response. Yes, because your response is always so enlightening. Every material fact for the 2 claims he's pushing is undisputed. And Jim's view of the law is correct, and my answer raises no viable defense. Well, your answers don't give a viable defense on the medical records thing. If you were told to only share the pleadings between the 2 parties by you posting about them on Twitter or your blog, is you not following the judge's orders? And so that one, I think, could be ruled on as the pleadings. If they think that by you posting this stuff out into the public violated the order, then I think on the pleadings alone, they could judge against you, put in a judgment against you. On the modest stuff, he might be right that certain things need to be flushed out if it comes to that. But if it doesn't come to that, if it is just the fact that you in your capacity as a lawyer did this during the dependency of a case going on or your appeal going on, and as a lawyer, they may not care about what was behind it. It was your actions, not necessarily whether what you said was true or false. Is whether it was true or false, should you have been doing what you were doing? And so that will be interesting to me to see if they do care about the truth about the statements he said, or do they say whether they are true or not, you are not allowed to behave like this as a member of the Arizona bar. So therefore, judgment against you. So I will be very interested in that one. Thanks for the warning. Okay. So he says, as the court considers those questions, because of the odd posture of the motion, the court is required to draw every possible inference in my favor, and it must assume that my side of the story is true. Well, you agreed that you did all those things, which is also Jim's side of the story. No, Jim is not the arbitrator. Jim is basically like opposing counsel, kind of. The PJD is the person that's going to decide this. Given the standards, I wouldn't hold my breath on Jim winning this. He has offered no proof of anything I said about Mata is false. And my answer specifically says my comments were all true. Oh, excuse me, just a minute. Okay, it should be unmuted now. And that's where, he's saying that they're true or that they weren't false, and that he needs to prove that what needs to be proven was whether they were true or false. But a truth could be a defense or a reckless disregard. And I think he was recklessly disregarding, and he had no evidence of this when he stated it. If he had evidence of it, then that would be different, but he doesn't. My answer also my speech is protected, which is a viable defense, as the bar knows, since they lost that issue in front of the U.S. Supreme Court before. Honestly, after looking at this, my view is Jim's position is so categorically groundless, I am attempting to ask for sanctions. But I wouldn't hold my breath on that part for either. For just now, I want to get the motion denied and then file my anti-slap motion. He said, also, there's been some huge Mata-related news. But long blog posts suck, so I will save that for next time. Okay. And then he talks about his motion for partial judgment on the pleadings. Okay. And nobody cares about any of that shit. All right. I'm not going to go into Rob's fee stuff on this particular one. He thinks that Reddit needs to fuck off. There's also a bar charge in there about his behavior with Reddit, which has nothing to do with free speech. All right. Right. He should. Just wrapped for the day. And it happened again. Somebody was on the internet was wrong again. Oh my God, who could have ever predicted that there are people that are wrong on the internet? Do you know how many stupid people I come across on the internet every single day that are wrong about so much? It's mind-blowing, some of the stupidity we have out there. But Gingras can't let things go. Exactly, corn-fed. This case, Hollywood would be like, are you kidding me? Because just when you think that that is the craziest thing, it gets crazier. Yeah, it does not prove it. All right. And this, I made a comment about when I saw this on Twitter. He says, I unintentionally saw a comment on Reddit where some idiot was trying to roast me because I didn't know the difference between a motion for judgment on the pleadings and a motion for summary judgment. And so there is no fucking way that you unintentionally saw a comment on Reddit about you. Because if you don't know how Reddit works, you can't just unintentionally see comments. You go looking for the comments on stuff or a post on Reddit. You can come across a post unintentionally. You cannot come across a comment on Reddit. Also, he is probably in the JFC Reddit looking up stuff, which is not unintentionally. So that line is bullshit. He said, so let me drop this tiny bit of knowledge. You're wrong, bro. You don't even have the sense to realize why. So let me help you, my sweet little keyboard warrior. When a defendant moves for judgments on the pleading, what does that mean? That means the defendant is claiming the complaint fails as a matter of law. He is so rude. And as Bruce always says, he's rude for no reason. Like he makes a conscious choice to be rude. And he talks about, oh, well, my speech isn't as rude as my writings. To me, if you can edit your speech for what comes out of your mouth, you can edit your speech when you're typing. And so his excuse about why, oh, when I'm writing things, I don't buy it. It's bullshit. You're a grown ass man and you can have more control. Oh, yep. New judge. Yep. He does. He is. To me, he's a jackass in everything he does. I think he can pretend to be a reasonable person when he wants to, but then as soon as you go against him, because he is not a person that can agree to disagree kindly. And he's always on one extreme or the other. You're either 0% wrong or you're 100% wrong. Because he is 100% right all the time in his mind. He says, when a defendant moves for judgment on the pleadings, what does that mean? That means the defendant is claiming the complaint fails as a matter of law. Not necessarily, in my opinion. I think it means that we don't need to waste time litigating this in a trial. And then we can just get these things off and not waste our time with this anymore. And then you just move forward on the other findings. Just like if other findings, you can just dismiss them. But he says in that posture, their moving party is the defendant and they are challenging the complaint. Okay, so hold on. Judgment on the pleading. I don't think that the judgment on the pleadings just means the defendant is claiming the complaint fails as a matter of law. Well, I think you do fail as a matter of law or on the matter of ethics. In that posture where the moving party is the defendant and they are challenging the complaint. What pleadings do/does, the court need to look at resolve the motion. Simple, the court only needs to look at the complaint because that is the only pleading being challenged. A motion is subject to a similar standard as Rule 12b-6 motion to dismiss for failure to state a claim. This standard requires that the allegations of a non-moving party be accepted as true and that the allegations of the moving party have been denied be treated as false, and further requires the facts be construed in the light most favorable to the non-moving party. Judgment on the pleadings is properly granted when there is no issue of material fact in dispute and the moving party is entitled to judgment as a matter of law. Well, there is no material facts in dispute on some things, and you deserve to have a judgment as a matter of law. It doesn't mean that the judgment is going to go in your favor. But he says, if the moving party is the defendant, the court only needs to review the complaint because that's the only pleading with facts we need to resolve. That's so simple, even you can understand it. But is Jim Lee the defendant? No, Einstein. Jim Lee is not the defendant. I am. Jim Lee is effectively the plaintiff. Why does this matter? Take a deep breath. You'll need extra oxygen to boost all 4 of your brain cells. Here it comes. When the moving party is the plaintiff, a different standard applies because, wait for it, the court needs to review both the complaint and, drumroll, the answer. He's so fucking dramatic. Yeah, he thinks everything is a lie, though. No sane, reasonable lawyer would act like that. It's just like, why do you need to act like this? He could have said, hey, I saw something that somebody posted, and so I just wanted to post that in a motion for summary judgment, it's this way, and a motion for judgment on the pleadings, it's this way. I hope that explains the difference in the two. He could have just been educational about it, but he had to be an emotional twat waffle about it. And good. Consider the pleading and the answer. I still think we end up in the same place. A plaintiff is entitled to a judgment on the pleadings only where the complaint sets forth a claim for relief and the answer fails to assert a legally sufficient defense. Yeah, he is a twat waffle. Or, stated differently, a plaintiff's motion for judgment on the pleadings should be denied where issues are properly raised by the answer. Oh, fuck, Reddit. Get it now? See, when the plaintiff tries to use the trick to end the case early, the judge don't gotta stop. Oh, they don't gotta? Well, that's good. Judge don't gotta stop with the complaint, which would mean it's really not like a motion for summary judgment. No. Nay. When the moving party is the plaintiff, the judge. Why is he talking so illiterate? Is he trying to be like, well, this is how that idiot spoke on Reddit, which I don't even know who the person that wrote this thing on Reddit was. But he wants to say judge don't gotta, and duh judge also gotta think about duh damn answer. Like, he thinks he's being slick and sly here and so cool about he's talking stupid to try to act like this is how you have to talk to get through to stupid people, which is flawed logic. Answer, because you know the answer also matters, because it's the plaintiff who is trying to win, and they don't win if the answer has a valid defense. Well, I don't think your answers are a valid defense, in my opinion. There may be some legalese, but I think you're unethical, and I think that you should lose on a bunch of them, if not all of them. But that's my opinion, and I'm not the one deciding this. Does that help you see a little more clearly? And does that help you now realize that what I said was 100% right? Because he's always 100% right. And there's 0% chance that a Redditor could be correct. Because everybody is stupid except for him. My answer raises all sorts of issues and defenses. These cannot be ignored in this posture. I realize Jim wants to pretend my defenses aren't a problem, like they don't exist. That's fine, except this isn't how it works. Man, I can't wait to leave this profession. And the thing is he can't leave his profession while he's under all of this. He can't just bow out and be like, "You know what? I'm just leaving." Look, Laura, I'm a real lawyer now who just happens to lose. He really could, Batty McBatface. He could really benefit from impulse control. And the fact that he can sometimes do it through verbal communication means he should be able to do it in his writing. And this is me covering his side of the thing, right? And it gives us the updates. Whether all of it is accurate or not, who knows? All right. So on March 17th, St. Patrick's Day, so happy Irish things. It was cold on St. Patrick's Day. I don't think there has been a reply other than Jim submitting the grounds on the pleadings, from what I know of. Minor update. In this video, I made a comment about how a party can't use privilege as a shield and not a sword, which I knew I was misquoting. This was referring to my view of the Arizona bar can't accuse me of lying about a judge while simultaneously claiming anything and everything the judge knows is privileged. So he's saying that the bar is trying to use Judge Mata as a sword and a shield. He said, "I found the correct quote. I was close. The case is talking about attorney-client privilege, but the rule is the same to form any form of privilege. If you bring a claim based on information that would otherwise be privileged, you waive that privilege." I don't think you had the right to say what you said, because you didn't have anything proving it to be true. It was reckless. Um and then he's bringing in circuit court stuff. Okay, and this one says, "The rule that a litigant waives the attorney-client privilege by putting the lawyer's performance at issue during the course of litigation dates back to Hunt v. Blackburn from 1888, where the court stated when Miss Blackburn entered upon a line of defense which involved what transpired between herself and Mr. Weatherford, her lawyer, and respecting which she testified, she waived her right to object to giving his own account of the matter. The court thought this proposition was so self-evident, it felt no need to support it with either citation or authority. or further analysis. In the intervening years, courts and commentators have come to identify this simple rule as a fairness principle. The principle is often expressed in the terms of preventing a party from using the privilege as both a shield and a sword. In practical terms, this means the parties in litigation may not abuse the privilege by asserting claims the opposing party cannot adequately dispute unless it has access to the privileged materials. The party asserting the claim is said to have implicitly waived the privilege. So that is, oh, there's more. I thought it was over with. Damn it. And he says there's tons of different updates through the years. And so he's sharing those. He says that for now, know this, the bar judge has ruled as of last week that I am not entitled to see the CJC's records on Mata. And he puts yet. Like I said, the CJC did not agree with him. He says he respects the judge's decision, but disagrees with it strongly. Well, I doubt you respect the judge's decision because you don't respect anybody that says no to you or doesn't agree with you. And then he talks about there's more than one way to skin a cat. While I have an option for immediate appealing the bar judge's rulings, I'm taking a more measured approach. That would be a first. I also served Mata with a subpoena asking for some information. Any correspondence she exchanged with the CJC in response to my complaint. Mata is in a different position than the CJC, so she can just raise the same objection the CJC used to block my request, which relied on CJC rules. But that effort may not work. It's up to the bar judge. Well, the bar judge doesn't seem to agree with your standing on things. If Mata objects and if the bar judge says she doesn't have to give me the records I'm asking for, there are two things I can do. Step one would involve filing something called a special action. Special actions are a type of immediate appeal while a case is still pending. They are discretionary, meaning the court, in this case, the Arizona Supreme Court, would not have to accept the case. But at the same time, I've seen special actions brought successfully under similar circumstances. So at least I know this is an option. Yeah, we'll see what the Arizona Supreme Court does with you because they have opinions on you as well. But there is also one more option, which is kind of a nuclear option, but not really. I might need to sue the CJC in federal court. Crazy as it sounds, this recently happened in a case with that LaSalle. I think we've gone over LaSalle before, and his posture on LaSalle, well, he says it's equivalent, and I don't think it is. But if you want to go look at it, feel free to. Civil Rights Corps versus LaSalle from 2024. LaSalle involved in an almost identical situation involving complaints against lawyers which were deemed confidential. A public interest law group asked to see records showing how complaints were resolved, but that request was denied. The public interest group then sued the judge responsible for overseeing the Attorney Grievance Committee, I guess the New York equivalent of the Arizona bar, arguing they had a First Amendment right to see those records. A federal judge ruled the New York bar folks could not withhold records of attorney discipline cases. In a long and extremely detailed ruling, the judge said the First Amendment requires the transparency so members of the public can understand if the government is working as it should. The amount of truth bombs was incredible. Yeah, Paul Berry, Mata is not a party to the case. That's right. Jim is the bar guy, corn-fed. Jim is the one that's doing all of this to Gingras. Yeah, it's not New York. Let me see. I don't know why he needs CJC records on Mata, though. That's what's weird to me. So he thinks that he has the right to see Judge Mata's disciplinary records. And everything like that. And I don't think that that's not the point of this case. The point of this case is the things that you did in this case. It has nothing to do with anything that Judge Mata has done in the past or anything. So I don't think you need those. And so I think it's stupid that you're trying to get those. And the CJC is like, you don't need this for this case. And so he goes through. First Amendment requires transparency so the public can, and the truth bombs. First and 14th Amendment to the Constitution prohibits that states from abridging freedom of speech, expression, and the press. Also, LaSalle was not, well, he was saying that was a federal course. Yeah, has nothing to do with the bar. Right of access only in criminal contact. There's no principle that limits the First Amendment rights of access to any one particular type of government process. The question is whether public access provides a substantial benefit to the proceeding's ability to carry out on its purpose. I don't think that Mata's CJC records substantially benefit or go to anything that David Gingras is trying to prove here. Even when he brings up the snake thing, whether she did a snake thing in a different case, we are not talking about that case. We are talking about the Owens v. Eckerd case and your blog posts. You have to stay on point. That has nothing to do with this. She could have been wrong in that aspect, but not here. I know you want to use it to show a pattern of her Googling, but you don't have any proof of that's what's happening. And you think that you need discovery to prove. The thing is, the fact that you have no discovery and no evidence to prove what you're saying is true means you shouldn't have said it. And that you knew by saying it, you had nothing that pointed to what you were saying being true. The fact that you need discovery to be handed over and all this evidence to be shown to you in order to prove that what you were saying was right means that you had no idea what you were saying at the time was right or wrong, true or false. Simple. Judge Mata's lawyer, Pamela, is going to let me know this week whether Mata intends to object to the subpoena, and if so, what grounds she's using to object. As soon as I have that, I will bring a new motion to compel in front of the bar judge. If the judge agrees with my side and orders Mata to hand over the records, that's the end of that. Although Mata could technically appeal. On the other hand, if the judge refuses to allow me to obtain relevant evidence necessary to my defense, then I will immediately file a special action with the Arizona Supreme Court. And I will also likely sue the CJC using the same logic that was successful in LaSalle. This is not that. I will tell you that right now. He says, one way or another, the truth will come out. You do not need her CJC records. They are not relevant to proving your defense. Nothing that is in her past and things like that have anything to do with anything. You don't need her audits, you don't need budget reports, financial statements. You don't need her discipline records. So I don't think you need any of this stuff. But to prove your defense, I don't think whether you have it or not helps you out either way. You just want it to have it. Well, even if the thing is he wants to see if she's been disciplined. Not every complaint that's been made against her, which he probably would like to see that as well, but that has she been disciplined by the bar, which I think you can kind of see that stuff publicly, but he wants something that's not out there. He thinks there's some missing piece of evidence that he doesn't have. And that maybe she's been doing things dirty forever is kind of how he sees it. Yeah, he made claims without evidence. And he knew what he was saying was speculative. That's not what I want. Okay. All right. He says, Happy Irish Things Part 2. I'm sure you enjoyed your Irish day. I said I'd provide an update. I said it would probably be later today. For once, my prediction was right. Well, good. I'm glad you concede that usually your predictions are not right. And just this one was. Just received this moments ago from the lawyer at the AG's office representing Mata. Since I was in the middle of something, issuing a subpoena for the robing room, the fact that you think that the robing room is something that is good for you is ridiculous. And there's a bunch of disgruntled people that didn't get their way. And probably, like, it's one-sided, the robing room. Like, you have nothing else. And when you're talking about this robing room and the snake comment, it wasn't material to the case. Just like whether Planned Parenthood is open on Sunday is not material to the case. Because even if you take that out, there are still things that have to be decided. And that has nothing to do with it. It was not a material fact. But he wants to trust the robing room and all the disgruntled people. Just like people that get bad grades on Rate My Professor and they want to go dog on a professor. Some of them are just pissed off because they don't like them. Based on a quick skim, I will say this. I appreciate Pamela taking the time to present her arguments in a thoughtful manner, supported with cases. This is very helpful. I will always take a look at everything she cited. I'll then do my own independent research, file a brief in response to this. Then the PDJ will have to decide what to do. Just one more quick comment. In my other post from earlier, I mentioned Jim Lee, a case Jim Lee says is helpful to his position. He said, odd that the only Westlaw citation is available since this case clearly says it's designated for publication. Yeah, I'm sure that's the only one that's helpful to his position. As I mentioned in my video, the facts of Olin were extreme, and I mean seriously extreme. Olin involved a lawyer who went nuts, going so far as to email a judicial officer, a commissioner. This is a threat. If I ever won the lottery, I would pay someone to off you. Yet that is a bit extreme. Or would pay someone to off that commissioner's minor child. Given that lawyer made a threat to a judicial officer, do you think that officer was excused from testifying at the lawyer's bar trial? Did the commissioner try to invoke privilege so that she wouldn't have to face questions? Of course not. I also don't think that they asked for that commissioner's CJC records and the things that you're trying to get. And if they couldn't get them in even an extreme case, if that's not something that mattered in a case, I don't think you're going to get them here. He says, of course not. This case clearly explains the commissioner who was threatened had to testify. During the disciplinary trial, commissioner testified that she was concerned because Olin had filed pleadings on an ongoing basis using berating language and what she perceived as escalating threats towards her. My point is simply this: judges can be witnesses, and here Mata is a witness. The only issue is whether I'm allowed to ask her questions and prepare a defense based on what she says. Clearly, that is going to happen. I've made wrong predictions over the years, but I'm pretty comfortable this wasn't one of them. And then he puts it in there. The thing is, the things you're going after, I don't think you're entitled to. You may be entitled to some things, but I think some of the stuff you're asking for is reaching and has nothing to do with any of this. It's just you doing things. He filed his response. What is this? Let's see. Let's see. In his response, he says he'll just say several things are filed today, including my response to the bar's "we win" motion. I also got a very interesting pleading from Mata's lawyer and an email from Mata's dad, but that stuff is not ripe for discussion. We'll get to that later. For now, you can really understand the issues without both the complaint. You can't really understand the issues without both the complaint and the answer, so I will post those here as well. If/when the bar files a reply, due in 5 business days, I'll add that. For now, I'll leave a placeholder without a working link. Note, it pains me to say this, but I need to place people on notice. The bar's complaint contains allegations that are 100% factually false. The neutral report privilege allows you to republish even false statements, but you must include a fair and neutral summary of the whole story. That means you must include a comment that says, I have denied any wrongdoing, and my position is bar counsel has made claims in here which are completely and totally false. Yeah, we know that that's your view on things. We also don't have to agree with that. Okay. Okay. Okay, so he has those. All right, let's go here. Yeah, it is a Yelp for judges. Exactly. It's just them going to bitch because they didn't win the case and they don't like the judge because they think the judge is biased. And maybe sometimes the judge is, but there's a lot of times they're not. Also, don't forget to like this video, subscribe. It is free. Help a girl out. Okay. And of course, he says Watergate, the AZ sequel, and will I resign like Nixon? Good God, this is not Watergate, but whatever. Let's see. He wants to talk about everybody. I don't care about any of that stuff about President Monica Lewinsky. All right. So his point about whatever all that shit is, which if you don't know what Watergate is, go look it up. It is a part of history that people should know about. What's my point? My point is during the last week or so, I've had some very odd conversations with Judge Mata's lawyer, Pamela, and with Mata's dad, and even the PDJ. As everyone knows, Mata and her dad and Pamela are fighting extremely hard not to let me see whatever they are hiding. So far, at least temporarily, the PDJ has sided with Mata, but based on history, I think that's about to change. Okay, so because of Watergate, you're going to get your way. All right. Since I became a lawyer, the legal fallout and lessons from Watergate fascinate you. Okay, great. History repeats itself. And he wants to talk about Watergate. I don't give a shit about Watergate. And as far as this goes, he said, so what fluff does Watergate have to do with Judge Mata and James Lee? Simple. Some people involved in the Watergate were caught and charged with various crimes. The prosecutor investigating the case eventually issued a subpoena demanding that he produce certain things and documents, precisely identified conversations between them. Keep in mind, this is what happened. Blah, 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 blah. After receiving the subpoena, did Nixon open his files and show he had nothing to hide? Oh, hell no. He objected to the subpoena, claiming it asked for confidential information. Sound familiar? He also claims some sort of executive privilege, excusing him from complying. Well, I think presidents doing things and this judge doing things are a little bit different. But he says the case went from federal district court, who rejected Nixon's confidentiality agreements. Not surprisingly, Nixon appealed, and rather than stopping the intermediate level appellate course, the case was fast-tracked straight to the United States Supreme Court. And the Supreme Court held that even a sitting president cannot withhold relevant information. The thing is the CJC stuff is not relevant to your case. What you're asking for has no relevance to what the bar is charging you with. So and that's the thing that he's not getting. He's missing the point. And he says, he understands that Nixon was a criminal case and the bar thing is not. And he says that makes no difference. Yeah, I think it does. He says the same rules of evidence and procedure apply in bar proceedings as in any civil or criminal case. Yeah, it has to be relevant evidence, relevant material. And what you're asking for is not relevant to the issues at hand. So it doesn't have to be handed over. You have a broad range of shit you're asking for that has nothing to do with what's happening here. I have accused Judge Mata of misconduct. I believe my allegations are 100% true. And I have also said, if anything I said was incorrect, I will gladly apologize and accept whatever punishment is appropriate. But what is Judge Mata's response to all this? Not just silence. She has actively fought to conceal relevant evidence. No, she hasn't. She is just not agreeing to hand over things that are not relevant to what is happening here. And he says, innocent people don't act this way. Well, you know what? Your client didn't hand over relevant information either. So it's funny that you put all of these things on other people, but when you or your client does those exact same things, it means nothing. Because why has things still not been handed over that was asked for in the Owens v. Eckerd case? Where are the original sonograms? Where's all this stuff that she said she did and she didn't? Why hasn't she ever handed all of that shit over? It's because as you say here, innocent people don't act like this. That was the right outcome. And the same outcome will happen here, I promise. And then he talks about Mata being appointed by a Republican. Who gives a shit? Mata is on the ballot this year, which means Maricopa voters will decide whether she gets to keep her job. If I succeed in discovering whatever evidence Mata is trying to hide, and if that evidence shows what I suspect it will, I think there's a good chance she will either resign from the bench, like Nixon, or she will be removed by voters. A single country judge isn't more important than that, like the president. He talks about it being a political thing. Who cares? Or maybe not. Maybe just Jim Lee does have evidence that I brought a bomb-sniffing dog to court. I don't remember seeing in the complaint that you brought a bomb-sniffing dog to court. So that's not even in your complaint. So you're talking about things that aren't even in there. Because if somebody remembers where that was in the filing, let me know, because that wasn't there. So you're not even fighting about that issue. He hasn't shown that evidence yet, and I don't think he ever will. It's not the question here about a bomb-sniffing dog. Jim can think that, but he didn't bring that in this filing. Maybe it was in the one before the amended complaint, but the one that's before everybody right now has nothing about a bomb-sniffing dog. He said that he is going to have a settlement conference, and he said he is going to make them a sweetheart offer. Call it an offer they probably can't and shouldn't refuse. But he's not going to share the details yet. He said, but if Jim Lee stops and really thinks about the terms that I'm going to offer, the odds of this ending tomorrow are pretty freaking high. I'll keep you posted. And P.S., I'm not a crook. Okay. Well, guess what? They didn't accept your offers. And why you have to bring politics in this is ridiculous. All right. Getting to page 1. Yeah, he is trying to ruin. He's trying to ruin her career. He's the one that's being retaliatory and vengeful. And it's just, his stuff doesn't make logical sense. But I want to tell his side of the story, so he can't say that we're not putting his words out there and telling his side of the story. But I also get to chime in and say my thoughts about his thoughts. And he talks about, oh, well, if you need something to cover, Ducky, you should cover this, this, and this. Thing is I have plenty of things that I can cover, but he doesn't shut his mouth. And right now, this is what is actively going on. And the other cases that I have, they are at a standstill right now, and not a whole lot is going on with them. And so I can get to those things at a different time. But he just makes himself look more and more unhinged with everything. And he's still saying that Mata did stuff wrong. Okay. Here's where he thinks I don't care about sexy Biltmore, whatever. But he says that he has figured out the JFC playbook. I didn't realize that there was a JFC playbook, but if there is, please send me a copy because I don't have it. He says that it is to post false info. Show us where we've posted false info. And you cannot attribute one person to everybody in what you call this JFC cult. He says it's for Jingy to respond, laugh, and repeat. Well, you do make us laugh, Gingras, because you're so ridiculous. It's very entertaining. It's also exhausting, just like your client's texts. But yeah, I guess you have it all figured out. No, because where's the false info? Let's see here. Data privacy trends for 2025. Okay. What is this? The Biltmore Embassy Suites. Okay. Don't care about that. But the only thing in there that relates to anything that we care about was he thinks he's figured out the playbook, which is wrong. He's wrong once again, at least about the first prong. So now, on March 20th, so 6 days ago, he went to the Arizona bar today, and he met with the bar guy. They sat in the same conference room where he has served as a volunteer arbitrator before. They didn't settle. There's a video that explains why. And he says, sorry about the fetus thing at the beginning. I just liked the song. Okay. You want to go watch that? You can go watch it with him. But yeah, we didn't settle. He didn't settle. We knew Jim was not going to settle with Gingras and take his offer. And then this is where he wants to talk about that the critics think that he's only ever worked on 2 cases, one involving a bachelor and one involving a cheerleader, which I don't know who actually thinks that. Those are just the ones you bring up quite a bit. But he says, he's done more than just that. He talks about a dog killer case. But he said that friend suggested JFC is very emotional and feels I have been This case was extremely interesting and upsetting on its own, but the reason I think it's worth mentioning is because of something a pro JFC friend told me recently. That friend suggested JFC is very emotional and feels I have been unfair towards Judge Mata. I responded and explained I disagree with the unfairness part, but everyone is entitled to their opinion. Um, he says that over many years of experience, that he has seen things that you haven't seen. He has seen people lie frequently, like your client, Laura. He has seen lawyers suborn perjury, like you did with Laura. I have seen judges make false statements. Sometimes they are not necessarily like sometimes it can be a false statement, but there was nothing malice behind it. You automatically assume lie, malice, the worst intentions when that is not always true. He says, those experiences have given me a perspective most people don't have. It affects how I see the world and how I respond to things. So, in mind, looking through that lens of my experiences, what seems fair to me may not seem fair to you. And he says, listen to the case. Mm, 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 mm. I don't care about this dog. It doesn't have anything to do with what we're discussing, but it might be something interesting to go look at. But so here he's saying, so her lawyer allowed her to lie in court multiple times. Was a notice of candor ever filed? Of course not. And guess what? The State Bar of Arizona did to that guy nothing. Yeah, but did he know that he was asking her to commit perjury? Whereas you should have known what she was saying was not true by looking at her patient portal. And so he thinks that he's like, so yeah, call me all the names you want, call me a liar, call me unethical, but don't tell me the Bar of Arizona cares about protecting the public. It does not. It never has. At least that's my experience. And it's part of why I'm very happy to leave this state. Well, great. The people in charge of enforcing ethics are some of the least ethical people I've ever seen. That is an unworkable situation for a person like me. And the thing is I'm not saying that to me, and a lot of us will probably agree, there is a lot that the state bar they don't go after. And I think if it was just a little complaint, they wouldn't really do anything, but it's that there is so much at one time about one case from so many different angles. And so that's why they are going after him. And it does take a lot for a state bar to go after an attorney. A lot of times, the state bar doesn't do shit about attorneys that probably should be disbarred. And so Gingras thinks that he's no different than any of these other people, and they've done things bad. So because they've done things bad and they didn't get punished, then he shouldn't get punished. But is there the same? I don't think there's the same fact pattern. I don't think there's the same things. And everything that you've done, it comes together and makes you look bad. If it was just about you asking a question and Laura lying about something, I don't think this would be a thing, but it's everything combined together into one that made them go after you. But he's going to say, well, they're selectively going after me because they don't go after other people who do the same thing. Just like when he's like, why you should go after Woodnick for this. No, they shouldn't, because what you're saying Woodnick did or what Dr. Deans did is not actually true. And your interpretation is wrong. in my opinion. And he can have the vile, disturbing interpretation all he wants. It doesn't make it fact. And it's, well, they got, just like, oh, they get to do it, so why can't I do it? There's times when you've done too much and it just can't stand anymore. And you've done too much, Gingras. You could have saved yourself from all of this. And he cares enough he wants to leave the profession, or at least Arizona. But he wants to do it on his terms, not be stripped of his law license. He wants to be able to leave on his own accord, not being forced to leave. Good Lord. Okay, let's see. I don't care about him almost suing Trump. Is there anything in here that has to do with any of the bar stuff? Okay, nope. That one doesn't pertain to anything. Monday Roundup. Don't care about any of that. He just filed his second motion to compel, which asks the PDJ to make Mata and her dad hand over things they are trying to conceal. When you do litigation for a long time, you can always sense when a case is at a crossroads. This is that time for me. If the PDJ rules against me, that is pretty much game over, except not really. Well, then why are you saying it's pretty much game over? I can appeal. We know how your appeals go. If it was anything like the last one, it's not going to go. And I will do that immediately, which isn't technically an appeal. It's called special action. If the PDJ thinks I'm not entitled to defend myself, they are not saying you are not entitled to defend yourself. They are saying what you're asking for is not relevant to the issues. Then we're pretty much done, aren't we? The outcome of the case has been decided at that point, which is really unfortunate. No, it doesn't mean that. That's you interpreting that if you don't get what you want, everything is going to be ruled against you. That's not how it's just not correct thinking. If he files a special action, then he files a special action. I don't know that it's going to go anywhere because, again, relevancy. Speaking of being done, the bar just filed their reply. In support. So there is a reply. Okay. If this was written in Mandarin Chinese, it would make more sense to me. The bar just seems to either completely not understand the case or they completely don't care about the truth or the law. They continue to completely ignore my defenses because if you ignore things, that means they don't exist. They also continue to completely ignore the legal standards, citing outdated case law, which has been overruled and ignored more recent cases that are bad for them. Sad, we need to expect more from folks in charge. And if they are citing things that are old cases and there's newer law on it, then that's not great. And Jim will not prevail on that stuff. Last week, the bar said they wanted to take my deposition. Unlike some other participants, I'm open and honest. So my immediate response is sure, anytime. Let's see. He thinks that he would have better luck teaching Aurora how to play guitar. But part of me thinks maybe, just maybe, if bar counsel asks me questions and listens to what I have to say, they will realize they backed the wrong horse here. No, they're not going to see it that way. Because what you did is repugnant, repulsive. A few months ago, I actually cared about this process reaching the correct result. Based on what I've seen, I no longer have that view. It's a lost cause. Not because I did anything wrong. Yes, you did. Because Mata did something wrong and she wants her revenge. No, you want revenge. That's why you're asking for things you don't deserve. You can't communicate with people like this. You just can't. You can't communicate with people like yourself, Gingras. Let's see. But there's much good news. While I wanted the truth to come out, the second most important thing was always this: if Arizona pulls my ticket, I was worried that they would send the order to California and try to have my California ticket pulled. This is based on something called reciprocal discipline. In a case of reciprocal discipline, if you get disbarred in one state, you will almost automatically get disbarred in all other states. You were licensed. That would be bad. It would mean I'm not a lawyer anymore. He said, but there's a catch. That automatic process does not apply if the proceeding of the other jurisdiction lacked fundamental constitutional protection. California business and professional codes. In other words, if Arizona fails to give me due process, California won't honor the AZ bar's decision. You're getting due process, Gingras. You thinking that you not getting certain things means that you're denied due process is just not true. Nobody's saying you can't put on a defense and defend the things that you were saying. There's just things that you don't need to defend that position. And they said, and they've said that you're not entitled to evidence because those evidence are confidential, which is actually not what the CJC rules say. You have the right to gather and present evidence in your defense, but they have to be relevant to what you're doing. You saying that Judge Mata is involved in this conspiracy thing with her dad and her sister and was biased against Laura because the sister follows The Bachelor and her father was not in the courtroom but in an overflow room that's not where Judge Mata and her dad cannot see each other. That her CJC records have nothing to do with any of that. If the judge says I'm not allowed to get any information from Mata, nobody said you couldn't get any information from Mata. They're saying the things that you're currently asking for are not things that you're entitled to. So he says that's pretty much game over from a due process perspective. It means I've already lost without a chance to present a defense. No, you're just being ridiculous. Even people accused of murder had the right to present a defense. They do. But there are things that are not relevant that they don't have the right to. Like in the Karen Reed case, I agree that when they were asking to look at all of everything that was in Proctor's phone was too broad. They do not have the right to look at anything and everything that is in Proctor's phone. They do have the right to get the things that pertain to her for Karen Reed's defense. And that's the thing that's happening here is Gingras has the right to things that have to do with him in this case. He does not have a right to everything and anything that ever had to do with her. It's too broad and it's vague. He said that would bother me if I wanted to stay in Arizona, but I don't. This year's already starting out to be one of the hottest on records. The last 2 summers were unbearable here. It's time for me to head to cooler climes. And while I would like to leave Arizona on good terms, that may not be possible. You could have left on good terms, and you could have checked your behavior. and decided not to die on the hill of Laura Owens and throwing your entire career away on that woman. Because I don't think she's worth throwing your entire career away. And then, even if this goes your way, you will still have to deal with the DUI that you're probably going to be charged with, or you're already charged with it, but you're going to be convicted of in some form or fashion. And then there's going to be that. So the bar and you aren't going to be done for a bit. So onward we go. The next ruling will probably decide the whole thing if the judge rules against me. I still have 2 moves left to play, but at some point, sometimes you just have to let the bad guys win. The bar is not the bad guys here, Gingras. They're just not. And you're spinning this into ridiculous things that aren't true. Okay. This one is from March 24th, so 2 days ago. Hanlon's razor. He really is. I just don't know what that is the one thing that I wish I could understand is why. Because he has not, I don't feel like I don't know if he's done this in the past, but we know as of recent, even with the Cody Wilson case and with Laura Owens, that I don't know if he's always been like this, but since him coming on to Laura Owens, his behavior, and it seems like every case that is involved, at least in the public eye, which are 2 cases, but he is just not there. I don't know what it is. I don't know what's going on with him. I don't know if he needs to go get a PET scan. But because I don't know what he's doing in his non-high profile cases. Maybe he acts like a normal person. But it's interesting that he's not out here doing PR for his non-high profile type cases. Or does he even have cases that he's working on? Who knows? We don't know. Well, I think the 6 days, 6 months plus a day, I think that was an offer. I don't know that that is the absolute punishment. All right. So he said it's going to be busy. He needs to file one thing, and then he needs to start working on written discovery requests to the bar, document requests, interrogatories, and requests to admit. It's hilarious because Jim Lee told the bar judge this case should be kept in the tier 1 discovery limits, which applies to simple cases. Each side in a 1-tier case is permitted 5 total hours of fact witness depositions, 5 Rule 33 interrogatories, 5 Rule 34 requests for production, and 10 Rule 36 requests for admission, and 120 days in which to complete discovery. I don't see why this wouldn't be something he needs. I know he thinks he needs more than 5 hours because of Mata and Mata's dad alone. But he says, so that's it. For now, I get to ask Jim Lee 5 questions, interrogatories. 5, obviously, I can and will ask the PDJ to raise those limits if needed. In theory, if Jim Lee is acting in good faith, he could voluntarily agree to raise these limits. I won't hold my breath. And I get not wanting to be I get wanting to just stand your ground and not give Gingras anything just because. Let him ask for it from the judge, and if the judge forces him, then he will, because you don't want to give Gingras anything other than what you have to. But at the same time, could he just do it? Yeah. Why not allow him? Because if you're so strong in your case against him, why not let him have more than 5 interrogatories or whatever the limits are? Why not give him just a little bit more? Like, and so I think if the judge thinks that he deserves more or should have more, then he'll hopefully give it to him if he needs it. But I understand why Jim Lee is like, not gonna do anything unless a judge tells me I have to. But Jim could also say, yeah, you know what? I'll agree to raise the limits. He said, but that isn't the point of this post. The point is, after reading the bar's reply on their motion for judgment on the pleadings, a line jumped out at me that was honestly shocking. And it says, as to respondent's second claim, incredibly, respondent, an Arizona attorney for almost 22 years, suggests that the plain and ambiguous language of the order is simply too vague to understand, as it did not contain the words "it is ordered" or use language specifically sealing the prohibited documents. Emphasis in original. Yeah. And I said yesterday, when he says that he just can't understand, it's a load of shit. He does understand. He's just going to act obtuse because he wants the ordering. And so he says, let me be clear. The person who wrote this just offered a textbook example of Hanlon's razor. Never attribute to malice what can be attributed to incompetence. And it is a philosophical heuristic known as Hanlon's razor. It suggests that negative actions or outcomes are more likely the result of stupidity, neglect, or ignorance rather than calculated evil intent. But you always see it as evil intent, Gingras. You always attribute malice to everything anybody does. And I'm sad for you that that's how you have to see it. I'm not somebody that trusts everything, but just to see the whole world as being malice and manipulative and evil, I would hate to live in that world. And I don't know what you've been through in life, but I don't know that your experience in life should put you there. I think you need therapy, maybe to help you with that. So he said, whoa, did I just call the bar guy incompetent? Well, maybe. My first thought was this person was being intentionally dishonest. But then I remembered Hanlon's razor. You can't always assume someone is evil. They might just be confused or uninformed, or a combination. And so, but you always go to the worst. So he says the quote that shocked me was referring to the let the record reflect issue. The backstory: Judge Mata issued 3 orders denying each and every single one of Laura's requests for confidentiality. Woodnick even argued it would be illegal for Mata to issue any order preventing the parties from talking about the case. Talking about the case and exposing private medical records are two different things. So he says, somehow the bar doesn't seem to understand this part. So let's review. Here are all three of Mata's orders denying sealing confidentiality. And then he wants to bring up so there was the October one denying request to seal. There was the February 15 one denying request for confidentiality and protective order. And then order 3, a few days after the February 15th request, February 21st, she says, see page 6, it is further ordered denying counsel for petitioner's oral motion to reconsider regarding the ruling concerning petitioner's motion for confidentiality. And he says, oh, let's not forget this part. As part of this successful fight against any all confidential sealing, in his objection here, Woodnick argued that Mata could not legally grant that relief. Okay. Yet you can't restrain impermissible prior to restraint protected speech, which just means that Clayton is allowed to talk about his case. That doesn't mean he's allowed to put her medical records out there. So let's recap. Laura asked and begged for confidentiality 3 times. Mata denied all that. Woodnick even told Mata it would be illegal to grant Laura's request. Yeah, because Laura wanted to make it to where Clayton couldn't talk about the case. That he couldn't say anything about her ever, which is not constitutional. And Mata agreed on that. Yes, because Laura wants everything to be hush-hush because she doesn't want anybody speaking out and pointing out her lies and the flaws in her version of events. Yeah. Well, he can't leave right now, technically. Go outside, Batty McBackface. We're almost done. So he says, yet in the face of all this, the State Bar Arizona claims passing the line, let the record reflect, and which said nothing about the filing documents under seal, was actually an order which completely reversed all 3 of Mata's prior orders, including an order denying Laura's request for reconsideration. No, it didn't. You're interpreting this all wrong. This just came to the medical records, not about talking about the case. That you were not to share medical records. You can talk about the case, but you cannot share medical records. And you did that. So he thinks that Mata's lying about let the record reflect. He thinks that she's reversing all that. He said, sorry, but it's not his fault. He says his interpretation of the dispute line is that Mata was telling Woodnick Laura asked for confidentiality and that she's denied those requests. But I better not see you, Woodnick, posting Laura's medical records on Twitter. That was in the thing. I don't think that was the exact quote. That is the only reasonable and legal way of interpreting it. No, it is not. Clayton never produced any medical records. So why? So Mata was telling Corey Keith what he could and couldn't share. She was only referring to Woodnick. And I think what she meant was Woodnick can't post Laura's medical records on social media. But either party can file them. But you didn't just file them, sir. She said both parties. And yes, your client's stuff was the thing. But the reason he was saying that Laura or Clayton couldn't do that was because Laura tried to say that Clayton was the one doing all this and sharing all of it. Because it couldn't possibly be her. sharing it. She was blaming Clayton. She did not want Clayton to be able to defend himself in the public. Just wanted Laura's story out there. He says, I'm sorry, that position is dead center in the middle of that. A court cannot legally order someone not to defend themselves in public against public allegations else has made. Nobody's saying that she couldn't tell her side of the story. It was just you could not share the medical records. And I don't know why you can't get that through your head. He says, unconstitutional vague orders are void. For this exact reason, the case has shown vague law transgress constitutional requirements. So if my reading of Mata's order is correct, I win. I didn't violate. Well, your reading and understanding of that is not correct. He says that his bar case is about to end as well. That he should have filed a motion to dismiss or an anti-slap, and it would have made his life easier. The anti-slap motion would have stayed the discovery, and it would have put things on a fast track for victory to him, in other words. And he said he chose the more difficult path of filing an answer, and it created a lot more work for himself. But I felt it was worth it because I wanted to get evidence showing that Mata did what I accused her of. But you didn't have any evidence when you made the statements that those were true. My plan was simple: get proof, then go back to family court and file a motion to have Judge Mata's judgment thrown out. Well, I don't know why you're trying to have her ruling thrown out, because the next ruling might be a lot worse for Laura if it does get thrown out. But sure. But as you have seen, I'm running into some obstruction conduct. There has only been one small ruling, but the ruling protected Mata. Fortunately, that was not the end of the fight. He says, if the PDJ will now get to decide, am I entitled to obtain evidence in my defense or not? You're allowed to obtain things for your defense. Certain things, not all things. Which he keeps arguing about the same stupid shit that I keep having to repeat. And notice the only thing he's focusing on in these blogs is about Mata. It's all about Mata. He hasn't touched hardly anything else. He's working on discovery request as of the 24th as well. He's going back over his complaint and answer to look at areas of factual dispute. As I was doing this, I went back and saw this stuff I said in my answer about Woodnick lying to the court. Oddly, I've noticed people posting videos about bar allegations against me, but as far as I can see, not a single person has raised any concerns about Woodnick lying to the court. Why not? JFC claims to be obsessed with punishing liars. Except for Woodnick, why? If you hate one liar, don't you hate all of them? If not, why? And that's because before he wrote this post, I hadn't gone over his answers because I touched on those answers. And you think that all these different things are lying. And I went over those things yesterday. This person says, we haven't seen the deposition, so I'm not sure that your quotes from Woodnick are in context or not. Are they correct or are they not? Question number 5. I only get to ask the bar guy 5 questions, which isn't a lot because I have to choose so carefully. Here's my current version of question 5. So we don't get to hear all of them, just question 5. So it says, post-trial minute entry order issued by Judge Mata on June 17th, 2024 contains the following finding regarding Dr. Samantha Deans, which is the Planned Parent that it says Dr. Deans testified that Planned Parenthood is not open on Sunday. When the petitioner testified, she sought care July 2nd. Given that trial transcript shows Dr. Deans did not testify or did not offer any testimony regarding the business hours of Planned Parenthood, nor did any witness, why did Judge Mata's post-trial ruling contain that finding? And how did Judge Mata learn Planned Parenthood is not open on Sunday? And that's a good question. I would like somebody to explain it to him. And I hope there's a good explanation. I think my explanation about it being an emotion that she had looked at about his blog is possibly the answer. Or she's just misremembering where she saw or heard that. She says, keep in mind the bar guy can't simply invent stuff out of thin air. He can claim I lied. Proving the claim takes admissible evidence, not online conspiracy theories. Oh, you're one to talk about online conspiracy theories. Your whole shit about Mata is an online conspiracy theory between you, your client, and her family. The bar guy made a serious accusation that I lied about Mata using ex parte evidence to support the finding about PP's business hours, but neither Mata nor bar guy has ever explained where this finding came from, if not from ex parte evidence. It doesn't have to automatically be ex parte evidence. That's the thing, Gingras. It doesn't. When I serve this stuff today, the bar guy will have to answer this question. And I don't know isn't one of the available responses. So that is Gingras's crappy blog. Should've, could've, would've, too late, Jingy. Whose hand size? And there, if you go on Twitter, let me see here. All right. Let's go. Okay. So apparently the Love Trapped episode, I've got to go listen to because I was watching Kelsey Fitzsimmons today. So I didn't have time to listen to Love Trapped this week. But we get to hear in the Love Trapped episode this week part of the deposition. And so the deposition that we get to hear possibly possibly goes to show that what Gingras is thinking is not actually correct either. And that he thinks Woodnick was lying. So definitely go listen to that. Because that may give us some stuff about at least the Woodnick lying plot. So I am excited to go listen to that because that's what I'm going to do right after this. And part two of the real estate stuff was put up today. I will put up part 3 probably tomorrow, which will be the final part of the real estate stuff. Yeah, it was before his time. And then I will possibly do a live on the other motions, the motion for summary judgment and response, or I may do a pre-recorded. But there will be some motions that I will pre-record that have been in there, like the motion to compel and motion where is it? The motion to quash and a non-party subpoena objection. I will go over all that probably in a pre-record. So it will just depend on what tomorrow night and Saturday looks like. But that's going to be it for me tonight. Schnitzel Ninja is doing the Stephanie Young interview like she does every week after each of the episodes drop. So go over there, and I am interested to see if I can figure out the rest of the emoji clues that she gives, because I know what one emoji clue is, but the 2 other emoji clues I don't know. So I am interested to see if it should have been like, duh. Like the penguin one I didn't get from the week before. And I'm like, oh my God, how did I forget about the penguin dancing with Chase J. Jones? But I did. I forgot about the penguins being in that video. So y'all go do all those things and enjoy your day, night, weekend, whenever you're watching. And I will see you next time. And let me see if anybody is streaming so we can do that. Let me do. What is that? I don't know what that is. Okay. I gotta view my channel because you gotta do it on edit video. All right, let me see if I can redirect to anybody. I'll send you over to Bruce the Moose. And y'all put duckies in the chat. So I will see y'all later.